The CFPB case says Congress is allowed to delegate this authority. The Chevron case is saying when Congress isn't clear about what a law is, how much leeway do the regulators have? So that's a real administrative power case. This is really how much is Congress able to say, somebody else do our job for us. So I don't see them as bearing on one another.
Welcome to The Debrief, where we talk with the Washington Examiner's top journalists about the headlines they're covering and where the story is going next. I'm Sarah Bedford, and I'm here with senior columnist Tim Carney. And Tim, this week the Supreme Court overturned a conservative challenge to the funding structure of the Consumer Financial Protection Bureau. Tell us about that case.
Yeah, so the CFPB was created after the financial crisis. The idea was it was supposed to protect consumers from bad practices by banks. But Elizabeth Warren, who wasn't in Congress yet, she was an advisor to Obama, she thought, well, we got to make sure that it's immune to outside pressure, so she made it immune to congressional oversight. So they created a government agency that's funded by the Federal Reserve. So Congress is supposed to control the purse strings, but it doesn't for CFPB. And again, a lower court conservative judge said, no, you can't do that. Congress can't just hand away its funding, its powers. But then the Supreme Court, including three conservatives, went ahead and said, well, actually, no, Congress passed this law. They're allowed to do that. Gorsuch and Alito dissented, but in the end, it means Elizabeth Warren won and her conservative critics lost.
What are some of the broader implications for this decision going forward for creative appropriation structures?
Well, so yes, it means that Congress is allowed to hand off its funding to something else. So, you could create a government agency that just has a profit and just pulls all its money from selling whatever. I mean,
That doesn't sound like a bad thing, that particular one.
Well, but in this case, they're pulling it from the Federal Reserve's profits. You could have it just pull all of its money out of a different government agency. And what it is ultimately it's a majority in Congress says, we don't want future majorities to be able to tinker with what we set up. The idea is, again, it's supposed to avoid sort of the lobbyists from having influence over it. That hasn't worked because all the early CFPB regulators became lobbyists. So, of course, they're going to be answering the calls of their former bosses and colleagues and supervisors. But it certainly does allow for creative funding. I remember it was bad when Ronald Reagan funded the Contras in South America by selling arms to Iran, and this sort of opens the door for Congress to create all sorts of funding streams like that.
This is not the only case that has to do with the administrative state and challenges to how big and powerful the bureaucracy has gotten. Does this decision maybe not bode well for other things on the Supreme Court's docket, like the big Chevron case?
So I think you can put them in different buckets because the Chevron case is not about Congress acting. This case, the CFPB case, says Congress is allowed to delegate this authority. The Chevron case is saying when Congress isn't clear about what a law is, how much leeway do the regulators have? So that's a real administrative power case. This is really how much is Congress able to say, somebody else do our job for us. So I don't see them as bearing on one another.
And there is an expectation that potentially the Chevron case could deal a blow to the sort of administrative state, right?
Absolutely. So right now, under current precedent, if there's any ambiguity in the law, the government agency, whether it's HHS, Department of Education, Department of Defense, they kind of get to decide what to do. These instructions weren't clear, we get to do whatever we want, and any court challenge falls down. If Chevron case, if that Chevron doctrine, going back to the original case, if that gets overturned, then really there will be real scrutiny. Is the government agency, is the executive branch following the law, or are they making up the law? Now, obviously, in recent years, Biden has enjoyed wide latitude in basically legislating from these agencies. If that gets overturned, then it'll be back up to Congress to make laws, and who knows what'll happen then. It'll be, going back to the Constitution, which would be wild.
Tim, that was an impressive amount of Chevron knowledge off the top of your head, because I did not warn you about that. Thank you so much for being here. You can get more writing from Tim and the rest of the commentary team at washingtonexaminer.com.